Hi, everyone, and I'd like to welcome my dear friend today, Emily Robinson, whom I've known since high school, although I don't know if that dates us or not. She is an amazing family law attorney who's been practicing for over 12 years. And one of the most frequent questions we've been receiving is family law related issues, whether it become from couples that are looking into getting married, who want to know what their rights are going forward, couples who, due to the uncertain circumstances we've been living in, have led to disputes within their marriage and looking to separate and want to know what their rights are, as well as child custody issues. So Emily, thank you so much for joining us today, and thank you for helping us answer some of these very important but difficult questions we've been getting.
Sure, I'm very happy to be here. Thank you for having me.
Of course. So we're going to get right to it. And the first question I have, and this is more my general curiosity, is I've been hearing that there has been such an influx in the filing of divorces as a result of the pandemic and being cooped up at home, not being able to go out. I think a lot of people didn't realize how much of an outlet their work was from their family lives. Is it true? Has that happened? And how has COVID-19 impacted the family law court system, filings, divorces, and the rate of divorce and whatnot? What have you seen on your end?
So what I've seen is in March, when the stay-at-home orders really started, everything just kind of froze. The courts closed. People stopped litigating. I think people just needed to step back, take a breather, try to figure out how they were going to navigate this world now. And then things were very quiet until about June, when the court started reopening again. And then there was an influx of divorce. I think people had just had it being stuck at home with their families and their partners. So I have seen over the last few months an influx in the number of divorce cases filed. But what I've also seen, which is interesting, is an increase in the number of reconciliations. I don't see that many reconciliations typically. Once people come to me, they've already tried to reconcile and been through all of that. So I think that some people who just kind of were going crazy at home with their partners pulled the trigger and then decided, wait, let me step back and think about if this is really what I want. So I have been putting a lot of cases on pause while people try to reconcile, which is great. If they can reconcile it, I hope that they do.
That's great. That's good to know. I mean, I could see how that would happen, when tensions are high and you kind of make a decision. And it's funny because it takes us not that long to decide to get married, but in a split seconds, if you want to get, separated or whatever, it's not that easy, especially like when you want to go down that path. So it's probably good to press that pause button and see if there is a way to reconcile. Now, in terms of the state that we live in, obviously, the division of assets is different from state to state. Can you tell us a little bit about, in California, as a community property state, what does that mean? So if someone is getting married and they're stepping into a marriage, what does it mean for the assets that they had before? What does it mean for the assets that they acquired during? And is there anything that anyone can do to protect separate assets, or how going forward in their marriage, if they really want to keep something separate in their own, what can they do to do that?
Sure. So in California, anything you come into the marriage with is separate property. So if you own a house before marriage or have retirement accounts before marriage, that's separate. But the second you get married, the community starts to grow. And anything that you acquire after that date of marriage until the date you separate, if ever, is going to be a community asset. So your income will be community, a house you buy together will be community, retirement accounts you start together will be community. The tricky part is what happens to the separate property assets when you start to contribute to them during the marriage. So if you come into the marriage with a separate property house, but then you pay the mortgage down while you're together, or you have stocks, but you buy more stocks while you're together, or you contribute to a pre-marriage IRA while you're together, then you start to gain a community interest in these assets. And there's formulas we use to figure out how much of the property is separate and how much is community. But it can be complicated. You typically have to hire accountants to figure it out. And that it's a complicated process to figure out what exactly is separate and what's community. Things that are always separate, inheritance and gifts are always separate no matter when you acquire them, whether it's before marriage or during marriage. So that, you know, if your parent leaves you a large inheritance, that will always be just yours unless it was left to both of you.
If someone is married and they're getting a large inheritance or they're getting a gift from a family member, like a lot of my clients receive gifts from their family in Iran, totally separate. Do you recommend that come into a separate bank account? Does that make a difference? And what if it comes into their joint bank account and then they start spending that money to pay community bills? Do they still have an argument later to say, well, that was mine?
That's a great question. So, that would be commingling, where you're now commingling a separate asset with a community asset. And the presumption in a community property state like California is that everything's community unless you can prove it's separate. So the burden is on the person who received the gift to be able to trace it back to the gift giver, prove it was their separate property, prove how much got commingled, and all of that, which is not easy to do. So yes, I highly recommend you keep it separate. You keep it in a separate account so that you don't have to worry about the commingling. And then if you use it to spend it on community items, you probably will not get a reimbursement for it unless you have a contract with your partner that specifically says, I'm spending X amount on a community item and I'm going to be reimbursed that amount in a divorce. Otherwise, it's just going to be probably considered a gift to the community. So that's something really tricky, whereas you're going through your marriage, you don't typically think about that. But yes, you do want to keep it all separate if you can.
So, okay, for example, so I'm not married right now, but let's say I meet my Prince Charming, hopefully one day soon, and I decide to get married and I have a house and I've paid off some of it, but I want to pay off the rest of it. And I want it from the get-go an understanding of, okay, I want to pay this off and I want to keep it as my separate property. What can I do? Because I think a lot of people think that if their earning comes into a separate account, then that means that that's separate. Whereas, well, if it's during the marriage and I'm earning money and it's going into an account, that's technically still considered community property, right? It doesn't matter if it's going into my own account. So there's like, so if I had an intent to keep that separate and I wanted my spouse or my partner to understand what would I need to do to safeguard that, or to make it clear so that if God forbid we ended up getting a divorce or getting separated, that wouldn't be a question or something that would be questioned?
Yeah, absolutely. That's a great question. The best thing you can do is to do a prenuptial agreement, where you outline exactly what is going to stay as your separate property. You are allowed to contract out of California law. You don't have to follow the community property law if you don't want to, but both partners have to agree to make a contract of exactly how their property and their income will be characterized. Is it community? Is it separate? Is some community? Is some separate? And ideally, they each have an attorney review this agreement with them and sign off on it with them, because having attorneys review the agreement and explain it to you makes the agreement much more likely to be enforced if that's ever a question in the court. And you can sign that agreement before your marriage, and then that will control how your property is divided. So you can keep a house separate, or you can keep whatever you want separate, as long as the other person agrees to that. And actually, even if you're already married, but you never did that kind of contract, but you still would like to do something like that, you can do a post-marital agreement that basically does the same thing.
Oh, I didn't know that. That's good for a lot of people to know. And it's not coming from a place of bad intent, but you know, if it's something that someone, let's say, because it could have been even something at a house that parents help them with the down payment, or what, you know, it's something that you want to just keep separate and pay for it separate. It doesn't necessarily mean that I don't want to share this, you know, with this individual. I mean, because I think that there's just this negative connotation that comes with the idea. Yeah. Whereas another way of looking for it is just, well, we want to, I get this is why I'm not married, but another way of looking at it is kind of like, you know, well, our intent is very clear, because one thing is I've seen in the cases that I've witnessed, both as an attorney because in my area of law, we have to always go back to, because a lot of funds that come from Iran or that was sent by family or whatever, when divorce happens, I mean, it gets so ugly and it's so heated, and people are really not, they don't really care about original intent. They don't care about discussions and agreements. It's more of a personal issue. So that's good for people to know. But everything else, so let's say if you have everything else, the house, the car, all the assets that you acquired together. So in theory, okay, it's community property, it gets split down the middle, but how is that in actuality enforced? So if you're living in a $5 million house, do you have to sell it and take that money separately? Or what if one spouse wants to continue living in that house because they have kids and they want to maintain some level of continuity for their kids? Is another spouse entitled to that same standard of living? Does it matter what one spouse is making, or how all of that factors into? I know I'm asking a lot of questions, but
no worries. So if you can agree outside of court, you can agree to almost anything that you want. So you can make an agreement that one spouse stays in the house, and then when the youngest child graduates high school, you sell it and split the money. Or you can agree that you sell the house, or you can agree one person buys out the other person's interest, either through a refinance where you pull cash out if they can do that, or through trading other assets. You can pretty much agree to any of that. If you can't agree, then typically the court is just going to sell the house, because the court doesn't have the time or resources to come up with creative solutions. And the court actually, many judges don't feel like they have the power legally to say, okay, you get the house, you get the retirement, because they're equal value, because those aren't the same kind of asset. They have different tax consequences. They have different present day value. So a judge won't usually do that. But if you're outside of court, you can absolutely do that if you want to. You have to be careful about things like if you do say, let's say the husband says to the wife, you can stay in the house with the kids until they graduate high school. The husband's name is still probably on the mortgage and the title. So he has to be aware that he's now tied to an asset that he doesn't have the ability to control. So if she misses a mortgage payment or something, it could affect his credit. He also may not be able to buy anything else until that house is sold, because his name is tied to such a big mortgage already. So there's practical aspects you have to think about. But some people, as long as those are explained to them, they're fine with that. And other people, it's just not financially feasible to do that, and they need to sell the house now to both be able to have the money to move on.
what about debt? Like, so let's say I do find that Prince Charming and I get married, and then all of a sudden I go on a crazy shopping spree and I rack up $50,000 in credit card debt while we're married, and then we end up getting separated or divorced. What happens to the debt that's acquired? Either it's credit card or buying a car or whatever. How is that factored in?
So debt acquired during marriage is also shared equally. And there's very few exceptions. So it could be awarded to just one person if that person breached a fiduciary duty and spent exorbitant amounts of money on something that would not be considered a community purpose, which is very few things like clothes, food. If I go rack up tons of money at shopping for shoes or purses, that's still going to be considered community. But certain things like gambling, or maybe spending money on a drug addiction, spending money on affairs or prostitutes, those are the very few things that would be considered a breach of fiduciary duty, where that debt would be awarded to just the breaching party. But otherwise, it's going to be shared 50-50.
Gosh, that's so important to know, though, because you have no control over that other person's spending habits or whatever, but then you could be in a position where you're going to be responsible for it as well. And what about gifting? If I wanted to gift, for example, my sister a large sum of money, would I need to get permission from my husband to do that? Would it need to be if it's coming obviously from assets acquired during marriage or income that I had during the time that we were married, would that person need to sign off on it?
So yeah, great question. Usually while people are married, they don't think about that. So they just do it. But yes, if you're going through a divorce and let's say the other spouse didn't consent to it or know about it, then they would possibly be entitled to their half back. So if you gifted $100,000 to somebody of community funds, your spouse may get a reimbursement for $50,000 when the estate is settled because they did not approve of that. And that could be also considered a breach of fiduciary duty because you're giving away community funds without the consent of the other person.
And then how about when you are looking for attorneys, who pays for that? So if one spouse is making more than the other, does that spouse have to pay for the other spouse's attorney? Do you have a legal right to an attorney or representation? Can you represent yourself if you can't afford to get an attorney to represent you? Because that's something that's come up a lot. And one spouse, if they have earning capacity, or let's say their family can lend them money, they can go and hire an attorney or a bigger firm or throw more money at it and drag it out, whereas the other spouse is at a disadvantage. How does that work?
Yeah, so that's a big issue that we face a lot. So the family code says that the higher earner should contribute to some portion of the lower earner's fees, but it doesn't say how much. And it's very much a totality of the circumstances situation. So it depends, like if let's say they had a prenup and one person has significantly more assets than the other, then there would be a high chance the court would require a big contribution to the other person's fees. But let's say there's no prenup. And at the end of the day, after one spouse pays support, they pay alimony and child support and all the assets are split 50-50, there may be no source to pay the other person's fees. So let's say somebody was a stay-at-home mom and the dad worked a lot, but after he pays his support and they split all the property, the dad has less income or the same income as the mom, then he's not going to also have to pay her attorney fees because there's no source from which to pay it. So a big aspect of that is identifying the source. Does somebody have a pot of money that the other person doesn't have from which they can pay the fees? Or are there no kids? And so there is no child support. And so one person has significantly more income to pay support from. So the court looks at all of that. And then there's also sanction fees. Those are fees that are really based on did somebody act inappropriately? Did they cause much more litigation than was necessary? And should they have to pay some of the other person's fees because of their behavior? But typically, ability to pay is still looked at for those kind of fees too. There has to be a source to pay it from. And then there's a few statutes where there's mandatory fees, like motions to compel discovery. Somebody doesn't comply with discovery. And then there's a mandatory fee contribution and those are more civil code things where your ability to pay doesn't matter. There is no right to a family law attorney. It's not like a public defender where you have a constitutional right. Probably about 80% of family law litigants in Los Angeles represent themselves because there's just not enough money to pay an attorney. So you can represent yourself. It's not easy, but many people do it. There is a right to an attorney in a few situations, like a contempt proceeding, because it's quasi-criminal. But aside from that, there's really not. So people do frequently have trouble getting attorneys.
So when someone is in a position where they have to represent themselves, how does the court respond to that? Is it like, do they try to educate them in terms of what their rights are? Are they looked at a little bit more? Are they cut a little bit more slack, or is it pretty much, well, we're going to have to treat you as if an attorney is representing you because that's just the way that the court has to function?
It really depends on the judge. And I think, though, that in general, judges are understanding of people that are pro per and try to make sure that they are directed to the appropriate resources where they can get help. So there's a self-help center. They try to give them chances to provide the right paperwork and things like that. If somebody looks like they're trying to get through this in good faith and do the paperwork they're supposed to do and making a meaningful effort, I think the court really respects that. If they are causing a lot of problems and filing emergency hearings every 5 seconds and, after being admonished by the court, still continuing to waste everybody's time and money, then I think the court can treat them harshly. They can, make them a vexatious litigant or sanction them. So a lot of it just depends on the person's behavior.
And what happens, because we're seeing a lot of this as well, people who have traveled to the United States from other countries and who have been living here, especially I've gotten a lot of calls just because of the type of work that I do. So they've been living here and then they've hit a point where they want to divorce their spouse. However, they were married in another country and they want to get divorced now here in California. How does that work? Does the divorce look at what was acquired here, what was acquired during the length of the marriage? Does it matter where the properties were, what they acquired and where and how? Does any of that, how does that play out?
So none of that matters as far as where the properties are, where they were acquired. The California court would have jurisdiction to divide all property of the parties. The California court would have jurisdiction to do the divorce for the parties as long as they've lived here for 6 months. So it doesn't matter where they were married. Where I see more problems is on the other end, where a divorce may be valid here, but if the people are from a country that doesn't recognize divorce or something like that, they have trouble getting the divorce recognized in their country that they came from, that they may want to go back to, or they may need to do further proceedings in their home country to effectuate whatever the California court did. But the California court will divide all the property no matter where it is.
Okay, and it's just a matter of being able to take that and then enforce it or have it recognized in whatever country you're in, because obviously
right.
they don't have the power to do that. Okay, so the last question I have in general is, if for both if you're in the situation of you're first getting married, so like let's say I come to you and I said, Emily, I'm getting married and I don't necessarily want a prenup, but what are some things that I should take into consideration? What would your advice be? And then the second question will be, if someone is actually looking for, is unfortunately hit a place where they are wanting to get a divorce, what you would recommend in terms of trying to keep it cost effective and fair to the parties involved, and try to keep it as painless as possible. I know that's probably almost impossible to do, but minimize the pain as much as you can, because that's one of the things I've enjoyed. I've watched a lot of your podcasts, and we'll put all of your information in the post so people can look you up. But that's what I really like, is that you're very, very well informed in the laws and the regulations, but it does seem like you do also push for the path that's going to cost the least amount of pain financially and also just emotionally for kids and everything. Oh, I will ask a custody issue after this. But so it's going to get married. What should they think of? And then if someone's on the brink of divorce or looking to move in that direction, what are some things to take into consideration to make the process as painless as possible?
Sure. So if you don't want a prenup and you're willing, to let California law control what happens in your divorce, I think it's good to know what the laws are and what you're looking at in the future, going towards that. The biggest advice I'd probably give somebody is, even though in a marriage there's typically a division of labor, maybe one person knows more about the finances because they just do more of the paying of the bills. Maybe one person's more involved with the kid activities. Maybe one person is, more of the point person for medical decision making and all of that. When you divorce, and hopefully, these people don't, but if they do, that stuff does not stay that way. You need to know how to do finances and invest money and balance your checkbook and make sure that you keep track of finances well. And you need to know who your children's doctors are and how to make appointments and where their school is. I mean, it sounds funny, but parents are busy, and usually one person takes the lead on different activities and tasks, which is fine. And it should be that way in a marriage, because you got to keep all the balls in the air. Yeah. Right. But if things aren't going well and you think you might be heading toward divorce, it's really important all this stuff, because you're going to have to co-parent and you're going to have to figure out your own finances at some point. So I can't tell you the number of people who come into my office and say, I have no idea what we have. They did all the financial stuff. I don't know. That's not a good position to be in, because now you have to figure it all out when you're at odds with each other. So it's really good to just know what's going on in your household in all ways, all the time, so that you have a shared budget file. So you know what is going on. Just even if you never divorce, it's good to have that knowledge. And then if somebody comes in and they're, divorcing or thinking about divorce, first I want to make sure that they've really tried everything that they can to save the marriage, because it's a hard road to turn back from once you start. And then, there's a lot of options that can be offered. Like, we offer consulting services where we don't fully represent you, but we help with paperwork, or we answer questions, or we can help in a limited capacity, so that even if someone can't afford a full attorney, there are options out there to get help without having to pay the price for a full attorney. And if you think you're going down that road, it's a really good time to get a snapshot of what's in every bank account, what are all the assets, because your date that you separate is the date that things are divided, as opposed to the date you actually divorce, which could be years later if the divorce takes a long time. So you want to know what was there at the time you separated. And so it's good to know that, and to make to have that information as, a saved file for yourself.
And then I know I said this was the last question, but this is actually going to be the last question. I'm being like my own clients are. It's like, one more question, just one more. And that is because we haven't really, we've talked about different aspects of it, but child custody, how is that viewed at? Is there a default way of going in? If one parent wants to get more custody, how does that work? And in a lot of cases, what we see is that, it's called 50-50, but one parent is taking more of the role and making the decisions and kind of taking control over it, and it leaves the other parent out. What are some of the things that you've seen? First of all, what is the law? And then what are some of the things that you've seen, and how can people kind of protect themselves from slowly being phased out of their kids' lives? Because unfortunately, that's something I see and hear about a lot.
Yeah. So there's two kinds of custody. There's legal custody, which is who makes the decisions. And there's physical custody, which is the actual schedule and timeshare. Legal custody is almost always joint, unless, one person is an addict or in jail and really can't make good decisions. But typically that will be joint. As far as the physical custody, so the law is that, there really should be joint custody so that both parents can be involved in the children's lives. But joint custody can look a lot of different ways. When a child is a baby, a lot of times the child is with the mother more for biological reasons, or maybe they're breastfeeding and it's just a necessity. As the child gets older, though, you see it becoming more of a 50-50 schedule. Now, the standard is best interest of the child. So sometimes it is not in the child's best interest to have a 50-50 schedule. Maybe one parent doesn't want 50-50. Maybe one parent is incapable of 50-50. Maybe one parent's mentally ill or physically ill. There's a lot of reasons why you wouldn't do a 50-50. But in a perfect world where everyone's healthy and able to take care of their children, that would be the ultimate ideal. But it's not always going to be the case. So, a lot of times parents end up litigating the custody, and the court will want to do as much joint custody as possible, where both parents have a lot of time with the children. But joint does not have to be 50-50. It can be 40-60. It can be 30-70. It just needs to be both parents have significant time. And the percentages, actually, I try to not talk about them with my clients, because all they do is pit people against each other. Mm-hmm. And I say, don't tell me you want 50-50, or don't tell me the percent you want. Tell me the schedule you want. What will be best for your children? How does it look on paper? Where are they Monday? Where are they Tuesday? Like, what works best for them? Because the percent, really the only thing it matters for is calculating child support. So I try really hard to say, like, tell me what the day looks looks like that's best for your kids. Don't tell me what percent you want because it doesn't sound good to you if you
Right.
have less than that percent.
See, that's why if you have questions, you should contact Emily. No, but that's such a good way of looking at it, because especially I think we all get bogged down on numbers in a normal way, but now when you have emotions and you're going head to head with someone and there is this division and there is underlying history and all of that, yeah, it makes you really want to focus on that number and say, well, why? No, it should be this and it should be that.
Yeah.
But thank you so much. This was so helpful. I mean, I've learned a lot. You know, here and there you pick things up, but I feel like one thing I've learned in this whole COVID thing and speaking with a lot of attorneys in different areas of law is the importance of understanding the law, understanding your rights, and not just going by what you think it is, or, well, this is how it is, or California says this because California is a community property state, or, but I thought this or that. And that's what I'm a big advocate of, which is why I try to do these types of programs. And I'm so grateful for people like you who volunteer your time, because you work, you're a mom, you're juggling, you have homeschooling, you have distance learning, you have whatever you call it. And then all of the things that come with practicing law under these crazy times. So Emily, I truly, truly appreciate your time. I'm going to put all of your information, contact information in the post. But if you just want to say, what is the best way if someone wants to contact you, what's the best way that they can contact you, that will be helpful as well.
Sure. The best way to contact me is probably email, because I get those the quickest as I'm in court a lot. And my email is robinsonfamilylaw@gmail.com.
Perfect. Thank you so much for your time. It was so great to see you. And
take
care, be safe, and we hope to have you on talking about other aspects of family law, because this is, I mean, I had so many other questions come up, but I tried to hold myself because we're talking about the essentials. But thank you so much and have a great day, and we look forward to having you again soon.
Thank you so much.
Bye.